Good evening, everyone. I'm going to announce 4-digit attendance code in 4 parts during this presentation. Every few minutes, I'll announce one of the digits of the 4-digit code, and at the end, after you've viewed the video, please email me, each of you, the 4-digit attendance code. All right. At this point, we've looked in detail at how the parties can customize or, quote, order, quote, their fiduciary duties to the entity and one another in the context of agency relationships, partnerships, limited partnerships, and limited liability companies. We first looked at this practice of customization under the model rules. For instance, RULLCA Section 110, which gives parties freedom to reduce, increase, or in some cases, eliminate fiduciary duties. We also considered some of the policy and practical arguments for and against allowing parties to modify the default fiduciary duties of loyalty and care. We learned that the implied covenant of good faith and fair dealing is basically the sacred cow of fiduciary duty analysis. It can't be completely eliminated. We also looked at some example drafting provisions that attempted to modify or privately order default fiduciary duties. We also considered how Delaware law permits parties to arrange or privately order fiduciary duties, focusing specifically on Delaware Code Chapter 18, Section 1101, the Fisk Ventures versus Siegel case, and the Kelly versus Blum case. Having said all of that, today we're going to look at the final area of fiduciary duty. That is, what's the remedy that I'm entitled to if I suffer harm as a result of a breach or alleged breach of a fiduciary duty by someone? If I'm harmed by one of my partners or co-members, can I sue him or her? How do I sue them? If I'm harmed by someone who's harmed the entity, must the entity sue that person? And what impact might a lawsuit for breach of fiduciary duty have on the entity itself? And as a practical matter, this is really what's most important to our clients. After all, what's right without a remedy? I want to talk a little bit about what we call the accounting remedy in unincorporated entity cases. So here's an example. Let's imagine you are in a partnership with several other people and you're in the business of selling vehicles. And the partnership has a dealership agreement with GM, and there's a partnership agreement among the partners that provides for everyone to pool their sales revenue because each of the partners works as a salesperson in the showroom. It sets up the establishment of capital accounts for each partner and the distribution of profits and losses pursuant to a formula based on each individual partner's actual sales of vehicles. And to complicate matters a bit, suppose that one of the partners owns the real estate where the showroom is located and leases it to the partnership. And also, assume that some of the partners loaned startup capital to the partnership instead of actually contributing it as at-risk capital, and are holding promissory notes issued by the partnership to the lending partner. Finally, one of your partners is the primary contact with General Motors related to the dealership agreement, and he also functions as office manager, overseeing bookkeeping and accounting. Let's call him the manager. Wow, this sounds like an exam question, doesn't it? Although the partnership agreement requires that the partnership provide regular capital account statements and reports to the partners, that hasn't really happened during the first 15 months of operations, since they've been so busy getting the business off the ground, selling inventory, paying royalties to GM, etc. In fact, no one really has any idea of what the partnership's finances look like, aside from these periodic draws that they take as wages from the partnership from their capital accounts. So let's say one day you're checking the dealership's mail and you find a letter from GM, you open it, and you see that it's notifying the partnership that it has 10 days to remedy a number of technical violations of the dealership agreement. And when you ask the manager what's going on, he shrugs it off and says, "Don't worry, I've got it covered." Well, fast forward a bit and imagine that this specific situation snowballs into an all-out battle between the partners with accusations of incompetence, theft, fraud, and although no one would literally say this in real life, at least not until they get to court, breach of fiduciary duty. So what is your remedy? Exactly how does this play out? The traditional remedy is what's referred to as an accounting. UPA Section 21 sets up the general principle that partners are fiduciaries for the partnership and are accountable to each other and the partnership for partnership property. And we've seen this concept referenced throughout the semester, of course. UPA 21 says every partner must account to the partnership for any benefit and hold as trustee for it any profits derived by him without the consent of the other partners from any transaction connected with the formation, conduct, or liquidation of the partnership, or from any use by him of its property. And it goes on to say that this section applies also to the representatives of a deceased partner engaged in the liquidation of the affairs of the partnership as the personal representatives of the last surviving partner. Section 22 is a related section that provides the remedy of an accounting in certain circumstances. It states, any partner shall have the right to a formal account as to partnership affairs, A, if he's wrongfully excluded from the partnership business or possession of its property by his co-partners, B, if the right exists under the terms of any agreement, like a partnership agreement, C, as provided in Section 21D, section we just looked at, and then goes on to say that whenever other circumstances render it just and reasonable. And I italicize that because obviously that's the open category that allows a lot of people to petition the court for an action for an accounting. So what exactly happens when a partner requests an accounting? So this would seem like the perfect solution for my problem with the dealership, right? Find out exactly what's going on. Unfortunately, unless the manager accedes to my request for information, I'll likely need to file a lawsuit in order to activate this procedure. Who pays for that? Also, what happens to any money that I recover? Our text describes the accounting remedy contained in UPA 22 as a partner's exclusive remedy for partnership disputes, or at least a condition precedent to any other legal proceedings related to the partnership. Why might that have been the case? Well, let's think about a couple of factors. Maybe because partnership issues are frequently intertwined and often have counterclaims, judicial economy requires that all issues be resolved in a single accounting proceeding. Or maybe because under common law pleading practice, a person can't be both plaintiff and a defendant in the same case. Or maybe it's because in complex inter-partner disputes were best handled under this special purpose accounting procedure rather than lawsuits argued to juries, because these issues tend to be quite complicated. Which brings us to the Sertich case. This is the Arizona case from 1989. First digit of the attendance code is 0. All right. I put on screen a diagram of the Sertich versus Mormon case, where we have CCP Limited, we have general partner down at the bottom, and we have a number of general partners of CCP on top and our plaintiff. What's going on here? So the plaintiffs are suing to enforce a limited partnership debt, which they purchased from Bunch, as in B on the screen, who had lent money to the partnership. We're told that in 1984, Bunch sold this $55,535.17 debt to the plaintiffs, but Bunch remained a partner. Remember, the economic or distributional rights of a partner are the only things that are freely transferable. So Bunch had lent money to the limited partnership. Instead of waiting to collect, he sold that debt to the plaintiff, presumably for some kind of a discount for the fact that he was able to liquidate it all at once. Now, we're told that the plaintiff then filed a suit to enforce the note that they purchased from Bunch. And that would be, in the particular case, they end up naming in the suit one of the general partners, Mormon, in our diagram M. In 1985, after Bunch sold this note to plaintiffs, the partners of the existing partnership filed a certificate of cancellation. What is that? Well, apparently it's a device in that jurisdiction that allowed a limited partnership to withdraw or cancel its articles of limited partnership. In other words, it was terminating the existence of the entity that owed the money to the plaintiff. Now, in its motion to dismiss, the defendants have several arguments. And they go like this. Bunch's debt was offset during the dissolution process to pay Bunch's other creditors, such that this note that the plaintiff purchased is now worthless. That's one of their arguments. Second argument they make is the plaintiff lacks standing. Since Bunch didn't sell plaintiff's Bunch's actual partnership management interest, the plaintiff has no rights to weigh in about the dissolution decision or process. Remember, he's just holding a distributional right, has no management rights at all. And according to the defendants, the remedy here, plaintiff's sole remedy, which he hadn't used, was to sue for an accounting. He's suing for breach of contract, not for an accounting. He's suing for breach of contract. So plaintiff is essentially a third-party creditor of the partnership, not a partner, and the partnership is now dissolved. Bit of a pickle for the plaintiff. So what was the procedural history here? We're told that the trial court actually granted the defendant's motion to dismiss, that the appeals court affirmed that, and it comes to this court, which vacates the second appeals court ruling and remands. In other words, plaintiff's breach of contract action was allowed to continue. So how did they get there? How did this court get there? Well, the modern Partnership Act has evolved beyond the common law rationale behind requiring an accounting as the sole remedy for partnership disputes, according to this court. They also point out the merger of law courts and equity courts, such that now all legal and equitable claims can be pled in the same action. There's no need to have a separate accounting proceeding as a condition precedent. They also point out the fact that there is the availability of something called a special master in all cases to deal with complicated issues. If there's some concern that this is too complicated for a regular judge or jury to handle. And they also point out that joint and several liability of partners under the UPA reduces the possibility of individualized claims against particular partners. Everybody's possibly liable. And finally, the court says this is really a relatively straightforward contract case, and therefore requiring the plaintiffs to go through this accounting procedure, this special procedure, is really unnecessary. Now, question becomes, can a party still demand an accounting under the Arizona statute? And the court says, yes, it just simply shouldn't be a condition precedent to obtaining relief in this particular situation. And the court writes, quote, this case illustrates that continued enforcement of the accounting rule is indeed illogical, impractical, and inequitable. The partnership was dissolved, the affairs wound up, and a certificate of cancellation executed. The alleged debt is of an ascertainable amount, evidenced by 2 promissory notes, and does not involve a partnership share, end quote. Now, at the end, the plaintiff didn't need an accounting. Rather, he simply wanted to get paid on the promissory notes that he bought from Bunch, which leads us to how the RUPA may have improved on the UPA treatment of this accounting remedy. I've put up on screen RUPA section 405, actions by partnerships and partners. How does this compare to UPA section 22? Now, keep in mind that There are 13 states that have not adopted the RUPA. In those cases, there still is this UPA Section 21 and 22 world that we have to live in. But under RUPA 405, it provides that a partnership may maintain an action against a partner for breach of the partnership agreement or the violation of a duty to the partnership causing harm to the partnership. That's pretty basic. But it goes on to say in Section B that a partner may maintain an action against the partnership or another partner for legal or equitable relief with or without an accounting as to the partnership business, to enforce his rights under the partnership agreement, to enforce their rights under this act, to enforce their rights as enumerated in this particular section. 401 is the partner's rights and duties generally. 403 is the partner's rights and duties related to information. In other words, I want to get information. And Section 4 are the general standards of conduct, including fiduciary duties. Now, the idea here is that it allows all claims to be brought against the partnership or partners in one lawsuit without the necessity of a formal accounting. And you'll note in Section C, it does not trump statutes of limitation. They can continue to run, and if they run, they're effective. This statute doesn't suspend statutes of limitation that might apply to causes of action. Now, of course, the parties are always free to draft accounting remedies into their partnership agreement, customize them, fine-tune them to the particular situation, to the particular business, to the particular business cycle, and the particular partners. I want to move on now and talk a little bit about some more remedies that are available in the partnership world. I believe we may have referred previously to a person's right to bring a direct claim against an entity or a person, and their right to bring a derivative claim in the name of the entity. So what's the difference between a direct action and a derivative action? Very generally, in the context of this course, a direct action is filed by a person or entity that suffers harm unique to that person or entity. In the example of our car dealership, if the partner, who's also landlord, is not paid rent for a particular month, she files a direct action against the partnership for the harm that she suffers due to her unique status as partner/landlord. In contrast, a derivative action or claim is typically initiated by a stakeholder in an entity against a third party who has caused harm to the entity. And because the harm is to the entity, the stakeholder's damages are the same as all other stakeholders, on a prorated basis, of course. And most importantly, the third party can be another partner, a manager, or an officer of the entity. Derivative proceedings are well recognized and codified in the world of corporations, since corporate shareholders are, by the nature of a corporation, relatively passive participants with no management rights otherwise. However, derivative actions are also available in the world of unincorporated entities, as we'll see in a few minutes. Oh, the second digit of the attendance code is 2. The second digit of the attendance code is 2. So here's an example of a corporate derivative action rule. This is Ohio Civil Rule 23.1, which I think I referred to the other day when we were talking briefly about this concept of direct versus derivative actions. So under 23.1 in the corporate world, it says in a derivative action brought by one or more legal or equitable owners of shares to enforce a right of the corporation having failed to enforce a right which may properly be asserted by it, the complaint shall be verified and shall allege that the plaintiff was a shareholder at the time of the transaction of which he complains, or that his share thereafter devolved on him by operation of law. The complaint shall also allege with particularity the efforts, if any, made by the plaintiff to obtain the action he desires from the directors, and, if necessary, from the shareholders, and the reasons for his failure to obtain the action or for not making the effort. The derivative action may not be maintained if it appears that the plaintiff does not fairly and adequately represent the interests of the shareholders similarly situated in enforcing the right of the corporation. All right. I want to highlight, I think I already have highlighted by italics, some of the, I think, important critical provisions of this concept of derivative actions. Enforcing a right of the entity. Now, the idea here is that the entity has been wronged, and for some reason, it has chosen not to do anything about it. Now, keep in mind that the entity may have been wronged by one of its own members, or partners, or managers, suggesting that the entity should essentially be suing one of its own. Obviously, we have a potential here for a built-in conflict of interest, right? Some hesitancy, perhaps, to go after the wrongdoer because they're one of us. The plaintiff needs to show that he demanded the entity take action against the wrongdoer, but the entity has refused to take action. Now, what's this about? Well, remember, under a principle we've seen, the business judgment rule, those who are charged with running companies, corporate directors, and by extension, general partners and limited partnerships, managers and manager-managed LLCs, enjoy a rebuttable presumption that they are always acting competently and in the best interest of the entity and its stakeholders. For that reason, courts are generally hesitant to second-guess the business judgment of these designated decision makers. Otherwise, no one would ever be able to run a company without being challenged at every turn. However, and this is important, the business judgment rule is a rebuttable presumption. In the context of the demand requirement, as we call it, a stakeholder may be excused from making the demand if he can prove to the court that making the demand would have been futile due to the manager's bias, let's say protecting their own or their colleagues' jobs, or some obvious conflict of interest. The third element I want to focus on in this derivative action rule is the requirement that the stakeholder who files a derivative action fairly and adequately represents the interests of all stakeholders. Why? Well, the idea of allowing a derivative action in the first place is because there's been harm to the entity that affects everyone equally. If the proposed plaintiff has suffered unique harm, then he or she arguably doesn't fairly and adequately represent all the stakeholders. So, for example, a member of an LLC is fired from his job. He demands that the managers sue the supervisor who fired him. This is clearly a situation where only the terminated employee is concerned, and therefore he or she would not be considered to fairly and adequately represent all of the members of the LLC. Why is this important? Well, as we'll see later, there are costs associated with these types of lawsuits, and the company doesn't want to have to waste money on this if it isn't affecting everyone equally. So let's see how it plays out when actually filing a derivative lawsuit. Plaintiff makes a demand on the control person, say a manager or a general partner, to file suit on behalf of the entity. And the control person either says, yes, we should sue the wrongdoer, all good, or no, we should not sue them. In this instance, the plaintiff typically alleges that the refusal was wrongful or biased and goes ahead and files suit in the name of the company. The company then moves for dismissal based on failure to comply with the statute, and the litigation involves the correctness of the control person's refusal in light of the business judgment rule presumption. Now that we have a basic grasp on the concept of derivative actions, let's look at it in a specific context, that is, the limited partnership. As our author points out, the RULPA doesn't contain a provision for direct actions by limited partners. Rather, it ties back to the RUPA provisions that we just looked at. This is another example of this linkage that we've been discussing at various points this semester, the linkage between the limited partnership statutes and the partnership statutes. So in this case, we're required to adapt those partnership rules to the particular wrongs suffered by the general partner or the limited partners, as the case may be. In terms of derivative actions involving limited partnerships, however, we do have specific. I'm putting on screen a series of statutes from RULPA section 1001 to 1004. And 1001 says, of course, a limited partner may bring an action in the right of the limited partnership to recover a judgment in its favor if general partners with authority to do so have refused to bring the action, or if an effort to cause those general partners to bring the action is not likely to succeed. Again, we have this same concept of derivative action being necessary when those in control have failed to take action. 1002, in a derivative action, the plaintiff must be a partner at the time of bringing the action and must have been a partner at the time of the transaction of which he or she complains, or his or her status as a partner must have devolved upon him or her by operation of law or pursuant to the terms of the partnership agreement from a person who is a partner at the time of the transaction. In other words, you have to have standing under the RULPA provisions. Under section 1003, it says that in a derivative action, the complaint shall set forth with particularity the effort of the plaintiff to secure initiation of the action by a general partner or the reasons for not making the effort. Again, this is that idea of making the demand or being able to explain the futility of making that demand as an excuse for not making it. Under 1004, and this is important, it says that if a derivative action is successful in whole or in part, or if anything is received by the plaintiff as a result of a judgment, compromise, or settlement of an action or claim, the court may award the plaintiff reasonable expenses, including reasonable attorney's fees, and shall direct him or her to remit to the limited partnership the remainder of those proceeds received by him or her. So in other words, if you're successful as a plaintiff, you may get your legal fees paid. Now, why is this? I would submit it reflects a policy of encouraging the limited partnership to act responsibly or to take its fiduciary duties seriously by penalizing it if it appears to have resisted taking action that would have improved the condition of the limited partnership generally. You'll also note that after the plaintiff's attorney's fees are paid, all the remaining money goes back to the limited partnership. Why is that? Because it's the limited partnership that was harmed, not this particular individual. But they did incur fees, legal fees, to head this up, to have the initiative to head it up, and therefore they get compensated for their legal fees. It's an important hammer in litigating these types of cases. Which brings us to the Anglo-American case. I've put up on screen a reference to Anglo-American Security Funds Limited Partnership versus SR Global International Fund Limited Partnership. This is another Delaware Chancery Court case from 2003. It's on page 411 of our text. So what's going on here? The general partner accepted money from the limited partnerships, of course, when they solicited the investments by the limited partners, and each of the limited partners had a capital account in the partnership. The claim here by the limited partners is that the general partner took too much money from their accounts for administrative purposes or whatever the general partner thought they needed funds for. So it seems like a pretty straightforward claim for breach of fiduciary duty, right? The control person, the general partner, took advantage of the relatively powerless limited partners. Separation of ownership from control equals fiduciary duty. So what kind of claims did the limited partners file in this case? Were they direct or were they derivative? Well, presumably they filed direct claims against the general partner because the general partner is defending on the basis that the claims should have been derivative. Now, why is the general partner making this argument that they should have been derivative? Well, perhaps because there are certainly procedural hurdles that a plaintiff has to meet in order to sustain a derivative action, as we know, and perhaps the defendants didn't believe the plaintiffs were going to be able to overcome those hurdles, and therefore they wanted to make them jump through the hoops of making it a derivative action, knowing that they weren't going to be able to meet those requirements. That's possible. So how does the court rule? Should this be brought as a derivative or a direct claim? Well, in the end, they side with the limited partners, and they claim they should have been brought direct. They were brought direct. The question is, how does the court get there? Well, let's talk about it. First of all, we have to look at the nature of the injury, as I said before. If it's unique to the plaintiff and does not involve the entities, it doesn't involve the, if it's unique to the plaintiff and does not involve the entity's rights, it's direct. And if it stems from harm to the entity, of course, and affects all partners on a prorated basis, it is derivative. The other thing to look at is the nature of the remedy. I alluded to this a minute ago. In a derivative action, any remedy goes to the entity itself, except perhaps legal fees that are paid to the plaintiff. In a direct action, the complaining stakeholder keeps what is recovered and the entity gets nothing at all. The third digit of the attendance code is 4. It's up to the court to discern whether a particular claim is direct or derivative, not taking how it is pleaded at face value necessarily. The corporate derivative action rules may be adopted to limited partnerships in instances where the relationship of the parties is similar to the corporate model, according to this court. But in the limited partnership context, there's always a limited partnership agreement, which has the ability to dictate the terms of engagement between the parties. The court here alluded to the fact that, quote, the operation and function of the fund as specified in the agreement diverge so radically from the traditional corporate model that the claims made in the complaint must be brought as direct claims, end quote. Of course, we wish we had that agreement to look at, right? Our authors didn't give us the actual text of that agreement, but it'd be interesting to see. In some cases, claims that might be determined to be derivative in the corporate setting may be better brought as direct actions in the limited partnership setting. So how does this apply to this case? Well, the plaintiff argues that the injury complained of, that is, the over-withdrawal of the limited partner's capital accounts, is not a violation of a right of the partnership, nor harm to the partnership itself, since it flows immediately to the individual limited partners through their individualized capital accounts. So rather, it's the nature of the direct breach of duty by the partnership to each individual limited partner for which they only have direct claims. If you take a look on page 413, note 8-11, it refers to this concept of direct recovery for what would otherwise be arguably derivative claims. All right, let's shift course a little bit and talk about treatment of remedies in the LLC context. In the LLC world, we have our own set of statutes that address these concepts of direct action versus derivative actions. And we'll see that they're fairly similar to the RULP provisions we just looked at. For instance, RULLCA 901 states that there is a direct action available to members. It says, subject to subsection B, a member may maintain a direct action against another member, a manager, or the limited liability company to enforce the member's rights and otherwise protect the member's interest, including rights and interests under the operating agreement or this act, or arising independently of the membership relationship. In other words, this is action. This is a remedy to a unique harm suffered by a particular stakeholder. And it goes on to say that a member maintaining a direct action under this section must plead and prove an actual or threatened injury that's not solely the result of an injury suffered or threatened to be suffered by the limited liability company. Unique action unique harm to that particular plaintiff. It goes on to talk about the availability of derivative actions, saying that a member may maintain a derivative action to enforce a right of the limited liability company if the member first makes a demand on the other members in a member-managed limited liability company or to the managers of a manager-managed limited liability company, requests that they cause the company to bring an action to enforce the right, and the managers or other members do not bring the action within a reasonable time, or a demand under paragraph 1 would be futile. Again, similar requirements as we saw under the corporate statute as well as under the limited partnership statute regarding the request or the demand that action be taken. 903 is this standing requirement that we've seen before. It says that except as provided in subsection B, a derivative action under 902 may be maintained only by a person that is a member at the time of the action is commenced and remains a member while the action continues. And if the sole plaintiff in a derivative action dies while the action is pending, the court may permit another member of the limited liability company to be substituted as plaintiff. In terms of the pleading requirement for the LLC derivative action rule, the complaint has to state with particularity the date and content of the plaintiff's demand and the response to the demand by the managers or the other members, or if a demand has not been made, the reasons the demand under 902(1) would be futile. What we've been discussing today are common law and by adoption, statutory remedies for breach of fiduciary duties. As we often learned in our investigation of unincorporated entities this semester, contractual mechanisms are always available for crafting solutions to issues between and among stakeholders, their entities, and control persons. That includes the ability to create or contract around remedial provisions. All of the statutes we've studied defer to the parties' ability to create their own roadmaps, except perhaps in the case where the contract provisions violate public policy. Should parties create their own remedial provisions, or are they better off relying on statutory remedies rather than spending the time, effort, and legal expenses of negotiating waivers of those provisions? What might a customized remedial provision look like? Well, I put up on screen some possible remedial provisions that could be included in a contract among stakeholders. For instance, upon the occurrence of an alleged breach of fiduciary duty by any manager, which remains unremedied for at least 10 days after such manager receives written notice of an alleged breach, the following procedures shall apply. Number 1, the party shall submit the dispute to mediation by a mutually agreeable mediator under the auspices of the American Arbitration Association in Cleveland, Ohio, utilizing the AAA's commercial mediation rules. And by the way, the AAA is a very widely used neutral tribunal, private tribunal for resolving these types of disputes. It goes on to say that such mediation shall occur not later than 30 days of engaging the services of the AAA in connection with such mediation. And the costs of the mediator and the fees charged by the AAA shall be paid by the company, and each member manager who chooses to engage his or her own legal counsel shall be personally responsible for such legal fees. And it even goes on to say that if mediation doesn't work somehow, the issue is going to get submitted to binding arbitration in Cleveland under the auspices of the AAA, in which case it's the final decision and talks about the fact that who pays the fees, etc. So this is one effort to customize the remedial provisions, in this case in an operating agreement. It could be in any kind of contract we've talked about so far this semester. Oh, by the way, the fourth digit of the attendance code is 8. The fourth digit of the attendance code is 8. So, on Monday, we're going to have our third and last in-class problem, and it's going to cover all the materials that we've discussed since the second in-class problem. And as I mentioned in class, it's going to consist of 10 binary response questions with the opportunity for some explanation in some cases. Again, it will be emailed out to everybody, and I'd like for people to be in class if they're able to be for this last one. You'll have the time of the class period to complete it unless you have an accommodation, and you can take this in-class problem wherever you have to if you have an accommodation that allows you to do that. On Wednesday of this coming week, we're going to change topics now that we're done with fiduciary duty completely, and we're going to talk about limited liability partnerships. This is a less common unincorporated entity type. It's basically a general partnership with some liability protections for partners in certain instances. Sometimes you see it abbreviated as LLP. We're going to find out exactly what that is. There is a supplemental case. It's not in the textbook that I want to address, the APCAR Investment Partners case, which I have put on Blackboard so that you can reference it in preparing for next Wednesday's class. With that, I'm going to end this session, and I'll see you all soon, I hope.